Hi, good afternoon, everyone, and welcome to the first session of the lecture Land Law. We're going to be looking at covering this particular unit in 5 learning outcomes, and there is going to be quite a lot of reading to do in terms of this particular unit. The reason I say this is because I've tried to collate a lot of resources, for the lecture, and also develop some of these presentations by looking at various sources, various books, articles and journals. There's a bit of reading which is involved in obviously getting yourself up to speed with obviously what is required to be covered in this particular unit of land law. Now, if I just quickly switch you over to the unit specification, which is what we've got here. The unit specification basically looks at giving us some guidelines into why are we going to be, or what all things are we going to be looking at in terms of studying land law. Now, one of the first things that we're going to be looking at is basically understanding about the principles governing land law. So there are going to be a couple of statutes, acts that we're going to be obviously going through, and they would include things like the Property Act of 1925. We're going to be looking at the Land Charges Act of 1972, the Trust of Land and Appointments and Trustee Act of 1996, and obviously the refined Land Registration Act of 2002 in conjunction with the basic bits that are defined in the indicative content that we need to cover. The second bit that we're going to be looking at is understanding key concepts about the nature of land law. And these key concepts would typically include things which are related to, getting ourselves familiar with things like property rights, ownerships. We're going to be looking at certain topics which relate to things like, equitable interests. What are the equitable interests? What are legal interests? How do we differentiate between personal and proprietary interest? So we're going to be looking at a lot of terms and definitions related to the field of land law. Now, these would also include, things like, if I just briefly highlight things like, we're going to be talking about the doctrines of tenures. We're going to be looking at doctrines of estate, ownership and possession. We're going to be looking at understanding what is equity and trust, what are notices, what are different types of licenses, what are the difference between the different type of licenses and ownership. We're going to be looking at property legislation and, to a certain extent, understanding some of the acts that I mentioned, which is the Land Law Property Act 1925 and obviously, the Land Registration Act of 2002. The final, outcome of obviously the main reasons of studying land law would be to also understand, in terms of developing a bit of an understanding in terms of a part which is that land law is essentially a part of property law. And here property can be defined in various contexts, and these contexts could be related to the condition of how the property is being owned, what are the legal relationships and entities involved, and obviously land in this case, when we talk about land law, is going to be known as real property, something which can be owned, transferred, licensed, and in some cases you could be dealing with someone in the case of inheriting a property if someone dies or leaves the property to you in the will. Now, last but not the least, we are also going to be looking at understanding, things which are related to, the various covenants of what is freehold property. When we look at conveyancing as an act, when you are looking at buying a property, what are the classifications? We're going to be looking at various, cases which are going to be helpful for us to build our knowledge in terms of how some of these acts and legislations have come into being when some of these cases have been tried in the court of law. So there are a lot of these cases which are there, which is Lloyds and Dugdale. We have Chowdhury versus Juarez. We have the Abbey National Building Society versus Can. We also have William Glinsbank versus Bolden, Thompson versus Fay, Link Lending versus Bustard. And, some of these, let's say, the cases would help us in building our understanding of how we can apply land law or the side of land law and the property law when we deal with various such situations. So you're going to be finding some of these cases as Word documents, which are going to be made available as attachments on Moodle, and they'll be falling under various, learning outcomes. So wherever there are relevant to the relevant assessment criteria, and also in some cases, relevant learning outcomes, you'll find them underneath as Word documents, so that you are able to use them also when you do your assignments, in order to use these as examples to elaborate on, cases which will bring out the application and your understanding on the land law. Last but not the least, obviously, I'm going to be referring you to books which are going to be available on Moodle. They will be for additional reading, and they would be putting the meat on the bones for you to be able to pick up on further details that we discussed, that we will be discussing using the PowerPoint slides. So if I switch you back to the Learning Outcome 1 and the PowerPoint presentation, what we want to be able to look at is today go into a bit of a discussion in terms of the unit aims and the indicative content which has been given. So we're going to be looking at covering that in 3 distinct parts. The first part is focused on understanding the nature of interest in real property. We're going to be differentiating between legal rights and equitable interests or rights. We're going to be looking at also distinguishing between personal rights and proprietary rights. We're going to be looking into the rationale and justification between, behind the special protection given to real property in contrast with regards to the peaceful enjoyment of property. We're going to be looking at licenses in detail. What are the nature, why licenses are different from leases? What are the various different types of licenses? Things like bare license, license coupled with interest or grant, contractual license, obligation of licenses and licenses. And we're going to be looking at certain, cases here to understand why it binds, parties when they sign up or, give out licenses, and how and whether third parties can be binded in certain circumstances. The second part, we're going to be looking at understanding the principles of registration of land. So here we are going to be studying the major act, which is the Land Registration Act, which came into existence, and it was, obviously it superseded the Act of 1925, the Land Property Act of 1925. What are the major changes which were introduced in this particular act? We'll be looking into that. And then obviously we'll be looking into understanding the 3 principles and the structure through which land register, things like minor principle, curtain principle, and insurance principle, and the property and proprietary and the charges register are maintained, and what are the reasons why they are important. We look at the types and classification of interest and registration, looking at differences between, when we talk about things like, what is an estate in land. We'll be looking at titles, absolute titles, possessory titles, qualified titles. We'll also be looking at overriding interests. And last but not the least, in the third part, we're going to be looking at co-ownership and trust of land, which covers basically, relationship between basically the nature of co-ownership and relationship between co-owners. Looks at joint tenancy or tenancy in common terms. We'll be looking at certain sections which are under the, the Land Registration Act statutory sections, which basically look at defining, let's say, severance under joint tenancy. We'll be looking at tolata, which is basically if disputes arise between, different parties, then, what are the rights for beneficiaries? What are the rights for the third parties? And in those cases, we'll be looking at certain, let's say, the sections, which is section 14 and 15, wherein, disputes arising in the case of land and how they are settled between co-owners and property owners, or people who have legal rights and, proprietary rights, and a party which may be eligible to make claims under this particular act. So there is lots to cover in the Learning Outcome 1 itself. And as usual, as always, I'm going to start off with looking at covering some of the basic bits in terms of key terminology, so which will help us develop a bit of understanding about land law and why is it a part of property law. So let's begin with discussing a few things, which is what does land law essentially cover. So land law is a part of property law wherein property can be defined in this context of being a condition where somebody owns a piece of land or a real estate or a property. And in this case, this can be transferred. This can be, let's say probate, which means sometimes, you inherit property, or you can inherit, this when somebody dies, and that is where you would be looking at, understanding, property law. So, or sorry, land law. Now, in the context of, land law being a part of property law, where property is defined in the context of being something that you can own or be, owned by a way of legal relationship, and that would be land. So in this case, land would be termed as what is called real property. And when we talk about land, it has some special characteristics as against some other types of property that we talk about. So it is unique, it is limited, it is permanent, it is indestructible, and some of the other things, which are other connected to land could be things like social importance. And in some cases, a person may own the property by having an ownership interest, and third parties might have an interest in the property. That means the bank, if, for example, you've taken out a loan or a mortgage, the bank would have, interest in that property until you paid off the principal and the interest. The bank would also have, some sort of possession over that property. And in some cases, an example would be that, you might have a piece of land, but the neighbor might own the, say, for example, have the access rights to be able to build a garage or have a garage over that property. And you might, in this case, have the ownership of the land, but the neighbor, or for example, the tenant also has the right to rent the property from that person, and as a result has the ownership under the tenancy agreement. So there are multiple things that we will need to understand when we talk about land law. And this is just a bit of a gist in terms of understanding, where do we start and, how do we look at defining basic terms. Now, there are some things that we are going to be looking at time and again. And when we talk about the concept of, land law, it can be traced back to, 1066 or, the 11th century, wherein William the Conqueror, victory over the Battle of Hastings established, when he conquered Britain, what he did was he owned the whole of Britain. That means he owned the whole of his state and the whole of the country. And he then handed out rights to be able to use portions of Britain to his immediate subordinates, aristocrats, in return for certain services. So what he did essentially was he became a landlord, or, obviously as a king, after winning the Battle of Hastings, he basically inherited Britain, or, conquered Britain, not inherited, conquered Britain. And this allowed him, and what he did was, after that, he basically used the rights, which he handed down to some of his subordinates, aristocrats, his key people, and in return, he, got services from them. Now, this could be, for example, a piece of land was given to, one of his aristocrats, and obviously that piece of land was used for farming. And in exchange, he used to get the contribution in terms of the farm produce, and that allowed him, he had the right to the ownership, but when he gave rights of the usage of land to some of his subordinates in return for services, allowed him, to use the land, to give out this particular land for a particular period of time, or tenure as we call it, and in return these services were then granted under that tenure. Now, over a point in time, obviously, this created a feudal system of land within the UK, and King, the Queen essentially owned all the land in Britain. Now, in the 13th century, the statute quo imperatives was prevented by splitting, this into lands, and, in order to basically look at abolishing the tenures. A Tenure Abolition Act of 1660 was introduced, wherein the Crown still continues to own all the land in Britain, but technically it is impossible to own your own land. So in this case, what happened was the estate, the fact that you own an estate in that land without, let's put it this way. So in this case, basically the Crown owns all the land, but in this case, the land is then also, leased out, or is given out, on a certain tenure basis, wherein, people are able to use that land for various activities. Now, If there are no heirs and there are no surviving relatives or there is not a will, then upon death, obviously the estate will be returned back to the Crown. So if there is no will and legal ownership or rights, if it doesn't, if the will is not being created and the person dies, then the piece of land that they own actually is transferred back to the estate. So when we talk about various types and how it has evolved, this gives you a bit of a background in terms of history. And when we go into some other details, for example, some of the key terms, which is things like what is an equitable interest in property law. So equitable interest in property law is basically interest that you have over the property, which gives the holder the right to acquire a formal legal title. Now, in this case, the equitable interest only exists in jurisdictions where common law background applies. And in this would be that, okay, a beneficiary would beneficiary interest would be, or a trust would actually have interest in the property. Now, when we talk about legal and equitable ownerships, what we mean by that is that in some cases, you may be a legal owner of the piece of land, and in some cases, the person or the third party would be an equitable owner of the same piece of land at the same time. Now, legal ownership is basically when you have when we see the origins of the legal ownership, this comes out from the rules of common law, and while equitable ownership comes out from the proceeds which follow from the rule of equity. So sometimes you would see that when we talk about rights, when we talk about whether you have equitable rights, legal rights, or legal interest, what that means essentially is that in some cases, legal rights would guarantee you or you will derive some sort of an authority because of the legality of the things. And in this case, when we talk about an example of equitable right, it could be seen in the land law, wherein it mentions that you are the beneficiary and you are the party which is supposed to be getting the vested interests from the estate, and that would basically be the equitable rights under that particular definition. Now, when we talk about land law in general, and I was giving you a bit of a background in terms of the history. So this is what is summarized here: is that obviously after the Battle of Hastings, William conquered the land and he basically owned the full land. Now, when we talk about modern sources of law and how they are derived, and obviously what we get to see in the court systems today, the Law of Property Act, or LPA, essentially of 1925, and the Settlement Land Act of 1925, the Land Charges Act of 1972, the Trust of Land and Appointments of Trustee Act 1996, and the Land Registration Act of 2002 actually make up what we would study under this particular unit, which is land law. So at its core, the English land law involves, things which are going to be dealing with acquisition, content, priority of rights and obligations, or amongst people with the interest or keeping in mind the interest in terms of land. And that is what is going to be the main focus of study for this particular unit. Now, when we talk about, you talk about estate in land. So an estate in land is essentially, the legal and beneficial rights and interest a person has over land and property. Now, the majority of land in this case is comprised under the Land Registration Act of 2002, which basically has simplified and updated the LPA Act of 1925. Now, the 2002 Act gives, the register which is maintained by the government, basically gives a very complete picture of who has the title, which means the ownership to the land and property, and shows clearly the rights and obligations and interest attaching to or affecting the land. So in this case, when we talk about, the estate in land, what we mean by that is, let's say the all estate and all land is basically owned by the Crown. But in some cases, what you will generally see is that, the usage and the, the legal and beneficial rights of the land would then be, dependent on the title and ownership, in terms of how you have the title and ownership, in terms of the, in terms of the particular piece of property or land. So when we talk about, and go in a bit more detail when we talk about, say, for example, the two concepts, which is what is estate land and what is legal estate. So theoretically, as I mentioned, all land belongs to the Crown. So in terms, you cannot own a land unless you have gone through you've undergone and obviously bought a piece of land under the Land Registration Act of 2002, and you become the owner either of the land as a freehold or under leasehold, which then is registered with the Her Majesty Land and Registry Department. So typically, properties when you buy a piece of land, you'll be looking at two aspects of it. One is primarily under freehold, and the other would be under leasehold. And once this is registered with Her Majesty Land Registry as a department, then is where you would own a piece of land. Now, when we talk about various aspects of, say, for example, some of the other terms that we would want to look at in particular, say, for example, things like ownership and possession, where we would basically look at ownership and possession would be that when we talk about freehold estates, you can classify them as that these freehold estates are in possession, and the immediate rights to those possessions would be primarily in return for the lease that you pay to the Crown. Now, in some cases, when you look at the owner of the freehold estate may also be able to grant a lease, and that leasehold estate, once the lease has been granted, would then allow the owner of the estate to use it for various purposes. Now, when we look at the owner of a freehold estate of land, in this case, you are the landlord. You have the right to be able to receive the rent from the owner of the leasehold estate, or you have the right to the proceeds, essentially, of the estate of land, because you are the owner of that property or owner of that land itself. So when we talk about freehold estates, they would basically be classified under what are called the doctrine of estates. We will cover that in the subsequent sessions, and that is what would help us understand and basically get into some of the major bits of this particular unit. Now, there are certain terms which are going to be related to things like legal title, equitable title, and some of these in terms of differences would come across when we cover some of the assessment criteria. So that is not something that I'm going to discuss now in the in key terminology part, because it will be a bit of a repetition when I start essentially discussing them under the assessment criteria. What I also want to do at this stage would be to primarily look at, covering what I've explained through a bit of a video. And that video, will give us a good understanding in terms of, what is land law, and essentially why do we look at, this from a point of view of an important piece of study when you're basically studying towards achieving your LLB degree. So let's look at this particular video.
Area of law that governs the different forms of ownership and rights of law that governs the different, focusing on land.
So let's look at this particular video, which will give us a bit of an idea in terms of what is land law. And I'm going to try and maximize the screen so that you're able to look at this particular in a video in a bit more detail. So give me 1 second. Let me get that going. Let me just bring that up. So I'll switch over now and let's listen into this video.
Land law is the area of law that governs the different forms of ownership and rights in relation to land. We're concerned with real property here as distinct from personal or movable possessions. The modern law sources of land law derive from a mixture of common law, equity law, and statute law. The main statutes that you need to be aware of are the Law Property Act 1925, the Law of Property Miscellaneous Provisions Act 1989 and 1994, and more recently the Land Registration Act 2002. Before we look at some of the topical issues, it is important that from the outset you are familiar with the definitions of certain key property concepts. Firstly, an estate in land. What does this mean? Well, essentially, an estate in land refers to the rights and interests a person has over a plot of land. Traditionally, it was viewed that all land belonged to the Crown, and therefore when you buy a property, you are actually buying rights and interest in the land. Pursuant to Section 1, subsection 1 of the Law of Property Act, there are now two types of estates in land capable of subsisting at law. The first is an estate in fee simple absolute possession, in other words, a freehold estate. And the second is a term of years absolute, in other words, a leasehold estate. Now, taking the first estate in land, a freehold owner enjoys the most extensive absolute rights in respect to the land. This can be contrasted with a leasehold owner who merely enjoys exclusive possession of the land for a fixed period of time. Now let us consider what an interest in land is. An interest in land can be either legal or equitable. The word interest in relation to land refers to rights a person enjoys over someone else's land. The list of legal interests can be found under Section 1, subsection 2 of the Law of Property Act, and most notably this includes an easement. An easement is a right of way over someone else's land. The categories of equitable interests include a beneficial interest arising under a trust. A trust exists when a legal estate is held by a trustee for the benefit of a beneficiary who holds equitable title in the property. The category of equitable interest also includes a restrictive covenant. A covenant can be either positive or restrictive in nature. A negative or a restrictive covenant is the promise by one person not to do something on someone else's land. A positive covenant is the opposite, i.e. a promise by one person to do something on someone else's land. Now that we've looked at estate in land and the interest in land, we can move on to consider some of the other topics in land law that you might come across. These include mortgages or a security interest in land, looking at the nature of easements and covenants, how they are created, and the binding effect of successors in title, both in law and in equity, adverse possession, and leases and licenses. You will also be looking at the registration of title, and I deliberately kept this last because it's a very important aspect to land law, and I want to look at this before we end this lecture. Land registration describes a system by which ownership and interest in land can be recorded. The purpose of registration is to simplify conveyancing and for the land registry to reflect the totality of estates, interests, and charges affecting the land. In effect, the registry acts as a mirror, reflecting the full range of proprietary interests and benefits in the land. The extent to which the system of registration achieves this is questionable, since there are many categories of interest which do not need to be registered. Following the Land Registration Act 2002, dispositions of unregistered land will now trigger compulsory first registration. Dispositions of registered estates also have to be registered under Section 27 of the Land Registration Act. The effect of registration is found in Section 29, which in simple terms states that a registered proprietor of land will take priority over interests which existed immediately before the disposition, i.e., for example, a transfer, and his priority was not protected. The section further goes on to tell us how a priority can be protected. A priority of an interest can be protected by either being the subject of a notice in the register pursuant to Section 32, or if it is an overriding interest under Schedule 3. Land law is a very complicated area of law, and you will have to refer to the primary and secondary sources of law in order to get a good understanding of its elements. Nevertheless, I hope this brief lecture was helpful. Thank you for listening.
So as you can see, basically it gives you a good overview of, what we're going to be covering as far as land law is concerned. And what I've covered in terms of the key terminology, the key definitions, and the key terms that we get to read, and we will come across them again and again, were covered in that brief understanding, of the video that I played. Now, in terms of one of the things that, as I mentioned earlier, would be to look at a bit of reading. So obviously there's a section, if I just quickly show you, which is the Land Registration Act of 2002. This is something which is going to be quite central to our reading of this particular unit. So the idea would be to try and familiarize by going into this particular act and going through some of the key sections which are going to be coming through, or we'll be referring through in the course of our discussions for this unit. Now, these sections would relate to Section 27, 28, 32, Section 1. There are some sections 14 and 15 of TOLITA, and then we'll also be looking at some of the sections like 36, of the Land Registration Act, which will be primarily related to tenancy and joint tenancy and when defaults occur. So you're looking at serving notices and things like that. Now, obviously, this particular act is available in detail on the .gov website. If I click on this, as you can see, this act is clearly explained and is an extensive document which can be referred in part to some of the sections that we are going to be looking at, not necessarily the entire act because it's a couple of pages, couple of hundreds of pages. So essentially, this is a link which I would suggest that you could basically look at, referring to, and it will be something that will be, useful when we do refer to the Land Registration Act of 2002 from time to time. Now, switching back to, where we are with regards to the first assessment criteria after covering the key terminology, we're going to be looking at comparing and contrasting some of the legal and equitable interests in land. Now, what I've done is, started off with a few definitions in terms of what is a legal title. And a legal title refers to responsibilities and duties of the owner in maintaining, using, and controlling the property. So a legal title is normally the actual ownership of the property. So if you imagine that you go out and buy a house, your mortgage is essentially, but when you apply and you exchange contracts and when you get the property, you are the legal owner of that property. So in terms of the documented name and the the documentation that gets created in the land registry, and obviously from a point of view of the ownership deed, you are going to be defined as the legal person who owns the title and the ownership to that property. Now, the legal title essentially grants you the true ownership of the property. That means you basically own the land and you own the property. And in some cases, anything which comes out from that land, which is things like mineral rights, easement rights, development rights, or anything that would be required that you would want to pursue as a benefit coming out of that piece of land, would be something that you will be able to do under the prerequisites of the legal title. Now, the legal title also appears in your name, and obviously as a, apparently it shows that you are the owner of that particular property, and it is something which completes, the legal title and allows you to then use the property in ways which you can use it for both, recreational and oblique enjoyment purposes. The other term that we look at is equitable title. Now, this particularly refers to the enjoyment of the property. That means you might be the legal owner of the property, but when you say, for example, if it's a house, you bought the house, but you put the house on rent, the tenant would have the equitable right under the tenure of the tenancy agreement. And in those cases, what you will generally see that the equitable title of the property till the time the tenure, of tenancy continues would be with your tenant. So it entitles the buyer of the benefits that they will be able to get or make use of under that particular agreement, and that is actually not true ownership. So they have it for a certain period of time under the tenure or the tenancy contract, and that is where they are able to then enjoy the benefits of the property, and that will be termed as what are called equitable title. So equitable refers to benefits and enjoy. What kind of benefit you get and what can you enjoy, and this is where it will not mean true ownership, but it will give you ownership for the duration or for the tenure for which you have signed the agreement. Now, when we talk about the differences, which is what is being asked in Task 1, we need to be able to relate to what are the key differences between the two terms. So when we talk about the main difference between equitable title and the legal title is that the legal title, gives actual ownership of the property. So in general terms, when we talk about, equitable title, it gives the person the right to be able to enjoy the land, enjoy the benefits. In this case, when we're talking about a house, the property, that come along with the ownership, which is primarily signed or given because the person may have signed the tenancy contract. And the equitable title does not, mean that you have transferred ownership or you've sold the ownership of the house to the tenant. It is only for a duration of a point time, or for the duration of the contract, that the person would have ownership to the property, and that would be from a point of view of not literally owning it, but enjoying the benefits that living in the house and whining and dining in the house, or basically using the property for various purposes, would be the benefits that the equitable title owner will get. A legal title owner cannot necessarily grant these rights unless they're defined in the tenancy agreement. If we go with the example of a house and the tenancy agreement, and here you would generally see that the legal title has the advantage over the equitable title, that it allows the owner to demand possession, or for example, if the rent has not been paid, then can demand that you vacate the property. And in those cases, those are rights which will ensue or will be provided for the title, the owner, in this case the person who has the legal ownership or legal title of the property. Now, there are some similarities as well between the two. There are minor differences apart from these, but these were the major ones that we have covered. There could be that, in certain cases you would also see that an owner might grant full ownership and use of property, and in such cases, you would generally see the property would be purchased under traditional mortgage loans. And what will happen is that the bank which will lend you the money or the equity to be able to buy that property would basically also own the title of the property, and this would be transferred on to the legal owner on the deed or on the ownership deed once the whole of the mortgage has actually been paid, or the finances have been cleared, both in terms of interest and principal, or in this case, as we say, till the buyer actually clears off or pays off the loan, and then the ownership of the properties and the title is transferred on the deed from the bank to the person, legal owner. So here in the first, learning outcome, what we need to be able to do is compare and contrast what are the differences between what is legal, title, what is equitable interest, and what are the differences between the two terms. The second assessment criteria talks about, differentiating between what we basically look at, what is called the personal and proprietary interest. So when we talk about, proprietary interest, these are rights that are, which are basically going to be allowing third parties, to be able to look at, for example, let's say. So if I put it this way, that when we talk about proprietary interest, it basically defines the rights and duties, which you are going to be related to when a certain party actually owns a certain piece of land. So in this case, what that would mean is that when we look at a proprietary interest in terms of land law or in terms of law, what that means is that you are holding the property of a private owner. You are basically related to the owner. You are showing the characteristics of the proprietor. That means you have been given certain rights by the owner or proprietor in this case to be able to make, use, market, the property for certain purposes as described by the owner of the property. And when we talk about, proprietary interest in land law, what we mean by that is that there are two types of rights that you must have when we talk about proprietary rights, and these tend to be rights in rem or proprietary interest. So when we talk about these rights, which give you the capability of affecting third parties, not just people who originally agreed to buying the property, but also people who are considered as third parties, then in those cases you would generally see that they will be, considered or are described under what are called proprietary interests. Now, when we talk about personal rights, what we mean by them is, or rights in personam, as in legal terms it is called. What we mean by that these rights are only going to be affecting the parties that are originally associated with the property. For example, a simple example that I've given is A gives permission to B to lawfully use the property for something. Now, this is under the, personal rights that he is allowed the person B to be able to use the property for, something. Now, this could mean that the person has licensed the property has, given the property out as a lease, and we'll cover that in the subsequent, slides, because we're going to be looking at differentiating between lease and, licenses. So, in general, when we talk about proprietary rights and interests, or rights in rem, they can be divided into different types. One is legal rights, and the other will be equitable rights. Legal rights in rem would basically mean that in this case, interests which are being capable of being legal are, going to be, related to acts which are covered under the Law Property Act 1925, some of the sections which will apply. And when we talk about, equitable, interests or rights, they would be all other interests which are necessary equitable. That means in some cases, they would basically be, obviously those rights which do not give ownership of real property, or, or be able to derive business from that property. So in general, when we talk about, proprietary rights and personal rights, in order to explain this particular bit, when I talk about, personal rights in particular, in terms of, let's say in the case of property law or land law, when we talk about, what we mean by them as a particular term is that these rights essentially would be, referred to as a right of performance or claims, legal claims, which you could basically, pursue when we talk about the performance in terms of third parties. So when we talk about, let's say, property right, this comes from a Latin word called personam, and this refers to the permission to use land for a specific purpose that is personal to the, owner. And in this case, when we talk about personal to the owner, what we mean by that is, in some cases, what will happen is that this would mean the personal right is distinct from proprietary right, which refers to the right that affects the land itself. So in some cases, you would have, these, let's say the personal rights, applying to land. But in this case, what will happen is that the clear distinction would be made from a point of view of contrasting it with regards to, what would be the rights which will, kind of follow through when we talk about permissions to use the land, and in some cases specific for specific purposes, when the owner has given you the right or the lease or the license to it. And when we talk about proprietary rights, it would be for the use of land itself. And in this case, when we talk about lease, we will be relating it to freehold versus leasehold. That is where these two rights would be different. Now, in order to basically understand this context and how do we differentiate between the two, there's a video that I have which explains this in a much more greater detail. And, if you watch this particular video, this would allow us to essentially, cover this up under what is called the, personal versus proprietary rights. So let's give it a second and I'll play that video. So let's switch over and watch this particular video, which is personal versus proprietary rights.
Today, in this video, we're going to be talking about some fundamental concepts in land law. I'm going to quickly recap on what is meant by an estate in land before having a little bit of a closer look at the difference between personal and proprietary rights in land law. Okay? So, first of all, the estate in land. Now, all land in England and Wales is vested in the Crown. So in 1066, William the Conqueror...
I'm going to skip that part because we've covered this in any case.
...for that land, 25. There are... okay, so... land count and the lease. It is possible to have...
So I've skipped that part because we've covered the estate in land and the two concepts, when we talk about essentially what is a legal estate and what is estate in land. And let's jump straight away into personal and proprietary rights.
Okay, so there are, it is possible to have even smaller rights over land than the freehold and the leasehold. and they will affect the freehold or leasehold ownership and the way in which that land can be used or controlled. So these are different rights affecting an estate in the land itself. So, for example, let's say that we have Claire, who owns the freehold estate in Blackacre. Her estate is therefore then subjected to the following rights. We have Liam, who lives next door in Whiteacre. He has the right to use Blackacre's driveway to access his house. We have Richard, who lives on the other side of Clare in Blueacre and has the right to prevent Clare from building on Blackacre. And then we have Katie, who has the right to use Blackacre's field every Thursday morning to host a farmers market. So these are three very different rights that individuals have over Clare's land, and they are rights that affect her freehold estate or her ownership in Blackacre. So although she has the estate and land itself, there are other smaller rights that can impact her enjoyment or use of that land further. So what is the difference? It's a very critical distinction to make here between personal and proprietary rights. Now, personal rights or rights in personam affect only the parties that originally created the right. So let's say X here, so looking at the diagram below, X, like Claire, is the owner of a freehold estate in land. Now let's say X and Y agree between them that Y will have a right over X's land. Then let's say that X then sells the land on to Z, okay? He's the purchaser of the fee simple or purchaser of freehold. If the right X and Y have agreed to is a personal right, okay, that right will therefore have no effect on Z under any circumstances, okay? A personal right will only affect X and Y. So X and Y, in the creation of a personal right, will not bind subsequent purchaser of the fee simple, subsequent purchasers of the freehold in that land. Okay? Proprietary rights or rights in rem or interest in land are capable of affecting third parties, and this is a great innovation of land law. So if X grants Y a proprietary right, so a right in rem or interest in land over that land that attaches to the land itself, so X grants Y that right in rem, what this means is that when X sells his land onto Z, okay, this right is capable of binding Z, okay. So be aware of this word capable that I'm using here, and I got it italicized on the slide itself. If the right granted to Y is a right in rem, it doesn't mean that it definitely binds Z. Whether a proprietary right does actually bind this Z, the purchaser of the fee simple, will depend on a further set of complicated rules, which I will discuss in a later video.
Stop. Did you know every...
So essentially, if we look at quickly going back into, the difference between personal and proprietary rights, we need to be looking at just establishing the definition in terms of, what the personal and proprietary rights actually mean. So in this case, which was clearly referred to, was that the personal rights would be rights or refers to the permission to the use of land for a specific purpose that is personal to the owner. And in the case of proprietary right, it refers to the right that affects the land itself, such as when you get a license or when you, lease the land under this particular context, then you'll be able to, use that for those reasons. Let's listen into the video again.
So these bubbles here are different rights in rem that we can have. They are different proprietary rights. Now each of these rights in rem has its own set of content requirements and criteria that need to be satisfied. So for example, in order for a right to be a lease, it needs to grant exclusive possession of a property for a fixed maximum term and arguably in exchange for rent. You cannot label a right as a right in rem which has a third-party impact without fulfilling these criteria. So, for example, if I grant you a right of non-exclusive possession of a property and label that a lease, that will not have an impact on a purchaser when I sell the house on. If the criteria is not fulfilled, then you do not have a right in rem. It becomes a right in personam, a personal right instead. So, therefore, any other right which is not in the above bubbles is inevitably a personal right, a right in personam. Now, numerous clauses is a crucial principle of land law. It dictates that rights in rem, proprietary rights, are limited to a finite subset. So they're limited to a finite number and ensures the number of these proprietary rights remains small. This is because allowing a right in rem to have effect can necessarily cause harm as a purchaser may be bound by them even if they do not agree to it. However, rights in rem do actually also deliver a benefit. Whilst they harm the purchaser of land, they obviously benefit the rights holder. So, for example, Liam, in the example that we showed you before, having a right to use Blackacre's driveway. Imagine Liam couldn't access his land without this. It is going to be very important to Liam that his right can be protected. If on a sale of Liam's right over the land was defeated and couldn't enforce it against the purchaser, he would be in a lot of trouble, as you can imagine. So the law's project is to balance detriment and benefit. So although there is an unavoidable and inevitable detriment, there is also often a benefit. So the law's project means that a right in rem will only be granted when the benefit outweighs the inevitable detriment. The bubbles represent situations where the law has decided that the benefit of allowing a right of that content to endure against third-party purchasers of land outweighs the inevitable detriment. Okay, so that was a very quick recap and a very quick overview of estates and land and the differences between personal and proprietary rights. If you have any questions at all, please just
So as you can see, obviously this gives you a clear idea in terms of, what are the differences between personal and proprietary rights. Now let's quickly delve into, the next assessment criteria, which is basically looking at understanding, what are the key differences between licenses and ownership. So when we talk about, licenses and ownership, we basically are going to be looking at, a couple of things first. Now, if we go into, the basic definition of what is a license. Now, essentially, when we talk about, let's say, let me look at when we talk about license and, the two terms that we're going to be looking at is basically licensing and leasing in this case. So when we talk about, the license in this case would refer to, say, for example, it's like a tenancy. It does not create a legal interest in land, but it's merely a permission essentially for you to be able to use the premises for a particular purpose. Now, this could be for a fixed term or this could be for an ongoing term, but a license does not grant you exclusive possession. So when we talk about license in the case of land law, we are basically looking at a personal permission that you are going to get to be able to occupy. For example, if it's a house, an accommodation, it gives you, so it doesn't give you, for example, the legal interest or control in the property or in the house. And the license is important is because if I term that license as a tenancy agreement, then the license or the tenancy agreement has to be there. Otherwise, the person, getting into that property or the house would be trespassing as far as the property is concerned. A license is always given out for a fixed term or is periodically renewed. And in this case, sometimes you would also see a joint license. It can also be held by one or more persons. Sometimes you see joint ownership in terms of property. You might see that the license holder would be a company or would be more than, would be held by more than one person. So in those cases, you would also see that the license could be, a joint license. Now, there are lots of cases that, will be used to explain how, for example, licensing actually works. So some of these cases, Hearst versus the Picture Theatre, Invest versus Maiden, Onks versus Beard, have been covered in Word documents, and you will see that on Moodle. Now, when we talk about, there is a further reading that you would also need to do to look at studying this particular case of Thomas versus Sorrell, in which, the licensed property was, the license to a property was done, but it did not pass or, alter any transfer rights, or the transfer rights were not given to the person, in this case Thomas, to Sorrell. So obviously this only ensued when it went to the court of law. It was only that the license to use the property for certain purposes was done or given, and there were no rights given to the ownership or the title of the property. Now, it's important for us to look at different types of licenses. Now, there are different types of licenses, so let's look at a few. Bare license. Now, this is a license which is given without consideration. That means, when we look at, you're invited to somebody's house for a party, and you've granted them a bare license. That means, in this case, the person who's come into your house, pretty much could look at, let's say, involving himself, or, could do a number of activities, and that is where this would be classed as what is called, a bare license. So when we talk about, a bare license, essentially, a good example of that would be that, a license which is given without consideration, in this case, for example, money. But when we talk about, the example of, say, for example, bare license, and sometimes when we also refer this to, as a different type, which is contractual licenses, the opposite of bare license. So in this case, you would generally see that, bare licenses would be wherein you would normally have, people having the freedom to be able to do things, and that is where it will be called a bare license. But when I talk about contractual license, this is a license which is normally given out of a contract, under the license, where the licensee is required to perform certain duties or pay for the services in return for the, license which has been given, or for the, let's say, the use of those facilities have been given. And in this case, a good example of this would be a tenancy agreement, wherein a contractual license ensures, wherein a tenancy agreement, a short-term lease, a short-term tenancy agreement, or a long-term tenancy agreement of 6/12 months would ensure that the tenant is required to pay rent on a periodic basis, and this license cannot be verbal, or this particular contractual agreement license cannot be verbal. It has to be written, and this allows certain, things to be defined in the, license which has been given under the tenancy agreement. Now, when we talk about, what are the various instances, if you just, let's look at it creatively in terms of what are the instances where licenses could likely be given. So, for example, when we talk about the government giving out license to firms to be able to use a quarry for digging out coal, for example. So they have given out a license for 5 years in return for a certain amount of revenue. You would see that sometimes license would also be required to be given in order to ensure that there is some sort of a legal relationship between two entities. You could also see that a license could be given in some cases wherein you would not want an exclusive right for occupation. So you might have a license given to, say, for example, a company. In this case, when we look at fisheries as an example, a lot of fishermen have licenses, and they can go and fish and farm for various produce from the sea, and this is not an exclusive license. So it is a condition under which a license is given. Sometimes you would see that these arrangements are also required to be done in order to create some sort of service occupancy, and that would mean when we talk about accommodation, and in those cases you would need to look at going into some sort of licensing under the tenancy agreement to be able to create a legal contract between two parties. So when we talk about licenses, there could be bare licenses coupled with a grant. In some cases, you would see the government would, say, for example, promote companies to open up businesses or take up or set up manufacturing facilities in a particular place in order to boost employment. And in return, they would also give them a grant to say you might be exempt from tax, pay a lower corporation tax, or in some cases, they would basically say, when I say a grant, the land would be given to the company to set up the manufacturing facility, in some cases free of cost. So there could be bare licenses, there could be license coupled with grant, and there could be contractual licenses, and these would be the three different types that you look at under licensing. Now, licenses can be revoked. So under common law, contractual licenses, bare licenses can be revoked at any given time. In some cases, when we talk about contractual license, like the tenancy agreement, you would give a notice, and it's defined in the agreement that you might serve as a landlord notice to the tenant, give them 1 month in terms of notice time, and then that tenancy agreement can be then revoked. Now, in some cases, you would see that sometimes when you try and revoke, a basic license, there is no problem, because in return, the money has to be either paid or returned. And in some cases, you would see if a bare license is revoked, there could be unfair consequences on this side, primarily for, either of the parties. Now, when we talk about, equitable, let's say, remedies. So when we talk about equitable remedies, in some cases, you would see that these are available to licensees in order to prevent, revocation. That means one party could not single-handedly cancel the license. And in some cases, you would see that the other party could bring in an injunction before the license is cancelled or is revoked. And in some cases, these are written down from a point of view of looking at, how licensing would work. And in some cases, what are the arrangements under which the licensing is actually worked out. So in this particular task, we have to basically look at covering the different types of license and the, what are the three different types, and using examples, you could explain bare license, licensing with contract or grant, and in this case, the third one being contractual license. Now, in the merit and the distinction criteria for this particular learning outcome, it talks about analyze how licensing differs from leasing. So as we have covered licensing and the three different types, what we need to understand is what is leasing. Now, lease arises or leasing as a process comes into fruition when a landlord grants a tenant a legal right to exclusive possession of premises, for example, for a specified period of time in return for payment of rent. And that would be classed as lease. Now, lease, unlike a license, could be, so when we talk about leasing, there could be short-term leasing, there could be long-term leasing. And when we talk about, the whole process of what is leasing in land law, then when we talk about the process of leasing, how does it work and what does it mean essentially, would mean that in some cases, when we talk about, leasing, it refers to, say, the ground lease. And this means that, the land is then leased out to as an entity to another party, and under this particular lease it is given out for a number of years or months, and in return the tenant the landlord would basically receive some proceeds from the lease, which could be rent, for example, or an annual rent for the lease, and this would be something which you would generally see as being classed as what is called the ground lease. So when we talk about, leasing in general, there are the concept of what is called ground leases in the UK. And these are normally given out for hundreds of years. And they were essentially developed as what is called landed estates, or with the going back to the same, key meaning of what is the estate of land. So essentially a ground lease involved a landowner granting a long-term lease on a piece of land or parcel of land to someone so that they could construct, build on it. And in return, the landowner then receives a steady long-term income, which is coming in the form of something called a ground rent. Now, traditionally, organizations, when we talk about, leasing in general, what we want to be able to look at is, understanding what are the advantages and what are the disadvantages of lease over license. So when we talk about lease over license, what we want to be able to do is basically, talk about the differences that we would want to, cover under, this particular task. When we talk about lease versus license in terms of land law in the UK. So essentially, when we talk about a lease and a license, the difference would be, as I've explained, literally that you are going to be able to get, say for example, the rights to be able to use the property or the piece of land for a certain period of time in return for the payment of rent. And some of the other bits that we need to be able to look at when we look at the analysis, which is required to be able to do in this task, what we need to be able to do is look at a particular case, which is going to be Street versus Mountford. And this particular case is something that I have, essentially, when I say would be available on Moodle, I'm just going to briefly show that to you as a bit of a document here. And that would allow you to, use this as a case to cover this particular task in terms of explaining what is the difference between a lease from a license. So this particular case, which is Street versus Mountford, is an essential one that will allow us to cover the difference between the two and also show the analysis which is required to be able to complete this particular task. Now, the other bits that you could also do is in terms of, when we talk about lease, and explain that in a bit more detail. So taking the reference of this particular case, you could explain, what is a lease. And in this case, the key element being, the tenant is looking at taking possession. And in this case, when the possession is taken from the landlord, this excludes the land essentially under which, the possession is granted. And that would be, covered under what is called a lease. Now, when we look at a license, so because it requires analysis, so what we'll have to do is get into explaining the terms and then obviously establishing, advantages and disadvantages of or differences between the two using the case like Street versus Mountford, and that would allow you to cover this particular task. So if I switch you back now to the presentation slide, so what I've also done here is after the basic definitions, I've covered what is a lease in detail. So it, if we take the case like Street versus Mountford, that helps us clearly distinguish what is a lease between what is a lease and what is a license. So a lease is likely to give rights to exclusive possession. It's likely to be for a fixed term, and it's likely in return you will be paying for that as a form of ground rent, or if it's an accommodation, or a theater, movie theater, whatever it is, in terms of some sort of rent. And the key element of lease being that you are going to grant exclusive possession. You can't have two people living in the house or two people renting out a piece of land to construct a factory. So in this case, the possession has to be exclusive. Now, in terms of license, when we've talked about the three different types of licenses, but just to summarize it here, it is a permission which is given to someone to do something on another property, and the permission tends to be related to a particular act. And if the agreement or the, some sort of a contractual agreement is not done, then in this case, it would also amount to being trespassing, and the other party could take you to the court of law. So a license would still attract a rent or a long-term royalty essentially, or a fees, and this would be for a fixed term. And in this case, what you will generally see is that when a license is given, it could be three different forms: basic license, bare license, contractual license, or license given with some grant, and that allows the owner or the person getting the license to be able to use that for purposes to benefit the business. And in this case, that would be for a certain period of time. Now, one particular example that I normally give out very clearly, in this case would be that sometimes when you look at, car parking spaces, you would generally see a piece of land has been given out by the council to a particular company, and they've licensed that particular piece of land to be able to, basically create commercial parking. And in return, what they do is when they, when you and me as users actually go into the parking lot, use that, we in return end up paying some sort of, a parking fee for a period of time. And in return, if I look at it, the council must have licensed that piece of land to the company for a number of years, and against which they basically get some sort of licensing fee, and that would be for a particular area because they are using it as a parking area. So this will help us cover, the first part of the learning outcome, essentially, to discuss, and then put in some other bits which are primarily related to the Trust of Land and Appointments Trustee Act, which is called the Tolata Act of 1996. I've also put some sections of Law and Property Act, which LPA, which will be quite relevant for you to read, and then the link to the Land Registration Act for some additional reading. And the key bits being, when this was introduced, or this replaced the LP Act of 1925, this basically made certain things simpler. So some of these things specifically it impacted were things like shorter leases, which were to be registered. It further encouraged voluntary land registration. It changed the system of protection from third-party rights, reformed and modernized the land law that we see in current shape and form today. It repealed some of the old acts like the Land Transfer Act of 1895 and the Land Registration Act of 1925. And they are key developments as far as we need to be aware of when we start studying this particular first unit, which is a first learning outcome, which is under the unit Land Law. So I hope this session you found it useful. There are these case laws which I'm going to upload up onto Moodle, which will allow you to build further understanding into some of the bits that we have covered today. And for any questions and queries, feel free to write back to me, on my email address, which is roman@ukversity.co.uk. And I'll catch up with you on Thursday for the second session under the Learning Outcome 2 for Land Law. Thanks for joining. Bye for now.